Can you point to anything, any information that you say was in the possession of the defendants that during this discussion period, you asked them to provide and they said, no way, we're not giving that to you? So that the only way you could get it was through a lawsuit?
I completely frank, Your Honor, I wasn't a part of those discussions. I'm a relatively new attorney.
Well, yeah, but I mean, you're here arguing. So I mean, that's
right,
not,
Your
a
Honor.
particularly,
That's not
a particularly helpful answer. I mean,
no, I know.
I argued a lot of stuff on appeal where I wasn't the trial lawyer, and your job is to know the record. And defendants said, no, go pound sand, so that you had to sue them to get the information.
I don't have any paper records that EGLE requested that information.
All right, so you have no records that the defendants refused any information. Why doesn't that just resolve the question right there? When a government agency decides to haul a citizen into court on enforcement action, that's a big deal for that citizen, right? We are providing access in our civil docket, both in the courtroom and also online. And we have up next a motion for attorney fees in Michigan Department of Environment, Great Lakes and Energy, the Dr. Bagney, file 25-9159CE. Counsel, you want to state your appearances beginning with plaintiff?
Good afternoon, Your Honor. It's Joshua Chonick on behalf of the Michigan Department of Environment, Great Lakes and Energy.
Dan Bach on behalf of the defendants, Your Honor.
All right, good afternoon. And I did receive and review the defendants, counter plaintiffs, although the counterclaim is in the court of claims, right?
Yes, sir.
Okay, so I just keep things simple for me. The defendant's motion for attorney fees and brief in support, as well as the plaintiff's response in opposition to that. And I thank you both for your pleadings, which helped me adequately prepare for the hearing today. Mr. Bott, go ahead with anything you want to say in support of your motion.
Thank you, Your Honor. Your Honor, I'm going to be as brief as I can here today, mostly rely on the motion and brief that were filed. But I think just a quick summary of some relevant points. And then because there's no reply brief, unlike a motion for summary disposition, I just want to respond to some of the things that EGLE raised in its response. So first of all, Your Honor, this motion is necessary because for two reasons. First, EGLE filed this lawsuit without adequately investigating the validity of its claims beforehand. And because it violated its enabling statute and raised an argument that was contrary to clear, unmistakable, longstanding precedent, including arguments that EGLE itself had made on that same issue in prior litigation. The defendants provided EGLE with ample evidence supporting that their activity was exempt from the requirements of Part 301. EGLE had this for 18 months before it filed this case. In other words,
let me ask you though, okay, there's a little bit more nuance to that beyond just the defendants saying we don't need a permit because this is maintenance or repair of an existing structure. They had applied for a permit. And then I understand that and I already ruled that I don't think that the plaintiff was properly handled that permit application. But it's not as if the plaintiff were coming knocking and saying, hey, what is this here? And they say, oh, it's totally permissible. And the plaintiff has to investigate that before they pursue some enforcement. Here, your clients were saying, hey, we need permission to do this thing. And then they ended up doing it without permission. So it seems to me that the onus on the plaintiff to investigate the claim is perhaps a little bit different calculus when they're saying, well, hey, they filed an application, a permit, and then they did it without. And look at this. This is a pretty extensive stone and riprap structure here, and we don't think that's proper. What did they have to do precisely?
well, Your Honor, I think the difference here, or the key point here, is that, and we acknowledged in the prior motion for summary disposition practice that at the time the application was filed, June of 2021, Dr. Bagney and Mr. Southwell were not aware that there was an exemption that applied. The problem is that a lot happened between that time, which is what EGLE has primarily focused on in its briefing, and the time that EGLE brought this case. 4 years passed, and during that time, it was in early 2024, in response to the violation notices, the communications that EGLE sent, that the defendants provided, I think, pretty significant evidence that carries their burden of production of demonstrating that there was an exemption that might very well apply. They provided photographs, affidavits. One of the affidavits from Mr. Stefan Bagny included a diagram that he made that showed the approximate location of the prior structure. They provided photographs and affidavits that showed there was still some stone remaining. And that was, as I mentioned, approximately 18 months before EGLE brought the case. Now, EGLE in its briefing has made the argument that the burden of proof is on the defendants in that case to prove their affirmative defense. I think the problem is that what defendants actually bear, and we talked about this in the summary disposition briefing, defendants bear a burden of production to produce evidence that shows that they have a defense, they have an affirmative defense. The burden then shifts to EGLE that it has to carry to prove that the exemption does not apply. And that's sort of the piece that's missing here is a year and a half before the case was brought, the defendants provided pretty ample evidence to show that this might very well have been exempt. 18 months go by, EGLE brings its case. We bring our motion for summary disposition with a little bit more evidence. We had gotten the documents from the County Conservation District and showed that it's highly likely that this was a permitted structure. And at that point, EGLE's response was, well, we need discovery to find out if this is true or not. And I think the issue is the stuff that EGLE said it needed to get through discovery is not the sort of things that are typically gotten through discovery. They're typically the sort of things that EGLE investigates before it brings its case. So, for example, in their response brief here, EGLE made the point that there is such a thing as third-party discovery, which
Sure.
I, of course, agree.
Sure, but your point is that they could have gotten this stuff without third party, without triggering discovery process in a lawsuit.
Exactly.
Or
Your
like
Honor.
maybe if they had tried to get it from a third party and the third party said, go pound sand. And they said, well, gee, we're going to have to go file a case and get a subpoena.
Possibly then, yes. But there's one more piece to this, which again, I would have normally briefed this in a reply, but not available in this type of hearing. EGLE uses historical aerial photos, historic permit records, things like that, in virtually every enforcement case that it brings. So those are the kinds of documents that always come up. If you're talking about a structure being built illegally, you look at the historical aerials going back year over year and see what it looks like. Those are all publicly available. The DNR and I believe the federal government have been doing aerial flyovers of Michigan since the 1930s. You can order them. I mentioned in our last hearing, I was EGLE's attorney for 17 years until actually 1 year ago tomorrow. I was the assistant chief of the environmental division at the Attorney General's office. We used aerials all the time. I never once heard of them being subpoenaed as part of the discovery process. These are publicly available services that you pay for and you get them up front. And then EGLE has all kinds of elaborate remote sensing software and things like that that it can use to determine the scope of an alleged violation. The point is that none of that was done here. And so it's a little bit different than, I think, your standard dispute between private parties where, EGLE in his brief said, well, we don't have an obligation to address an affirmative defense in our complaint. Well, but I think the issue is that when the complaint is a law enforcement action brought by a law enforcement agency, and it has been in possession of potentially, I'm going to say, exculpatory evidence. It's not technically exculpatory because it's a civil case, but evidence that potentially contradicts the gravamen of its complaint. They've had it for 18 months. It comes up on summary disposition, at which point they'd had it for approximately 2 years. And the response is, well, we need to conduct discovery to get publicly available documents, look through agency permit files, which they never said what agency files those were, but EGLE is the permitting agency. And they're the ones that would have those files, although, as we pointed out, they were probably lost to history, basically, because that was the days of paper permits. And we would be outside of the state's retention policy, given how old the structure is. And then, so to bring that case without vetting those claims, that puts a significant financial burden on the defendants to defend the case. And it's not only a financial burden, but it's a reputational burden. I mean, for 4 years before this case was filed, the defendants had this hanging over their head. Mr. Southwell is a contractor who does this type of work in the area, and it's been known among the community that he works in that there's an enforcement action dealing with things he did in his job. And I think this should have been more thoroughly investigated and vetted before it was brought. I think that falls.
But I mean, but it's not that there was no investigation, right? I mean, I've got the affidavit of Mr. Olming, I don't know if I'm pronouncing that right, saying, documenting these phone calls about alternatives that would be less impactful to the river. Nobody's told him about the pre-existing structure. He was told that it was already started. So he went out there and did a property inspection. The work had been completed. He says he didn't see any signs of pre-existing structure. He wasn't informed of any pre-existing structure. I mean, they did some investigation, and then now granted, obviously I agreed with your client's position and granted your motion for summary disposition, but what is the plaintiff's duty to investigate what they think may just be a self-serving affirmative defense that they think is, baloney, and they're going to go forward with their case anyway, and they just don't have confidence that I mean, they don't need to investigate to disprove the affirmative defenses, right? I mean, that's their point.
That's correct, Your Honor. You don't have to investigate to disprove an affirmative defense, but when you have evidence in your possession already that there is this affirmative defense, I do think they have an obligation to investigate it and vet it, because if that affirmative defense is proven, then they have no authority to regulate the issue at all. And as to Mr. Oming's affidavit, and Your Honor did pronounce it correctly, as Mr. Oming, what he's referring to is the time in 2021, the initial application phase, which I won't recite the entire history.
Right, but so you're saying that question too narrowly focuses on that slice of time.
Yes.
And we need to look at the whole slice of time prior to the filing of the complaint.
Yes, Your Honor.
And that there was, before the filing of the complaint, enough information to provided to the plaintiff that would have triggered some duty for them to make sure that they've investigated this and are bringing a well-supported enforcement action.
Exactly. And I think that's right in line with the precedent, particularly the Meisner Law Group case, which is the case that said, attorney fees are appropriate because when they prevent frivolous filings and arguments, in that they deter parties and their attorneys from filing or asserting claims or defenses that have not been sufficiently investigated. And in that case, the Court of Appeals said, when you look at that, you don't look at their subjective good faith intent. I don't think anybody alleges EGLE had any bad faith here, but you look at whether there was an objectively sufficient investigation into the claims before they were brought. And if they were not, then attorney fees are appropriate in that situation. And I think here, Mr. Oming's affidavits and much of EGLE's argument focuses on the summer and fall of 2021 and what was in the permit application and what was said at that time. The problem is 4 years passed after that before the case was brought. And it was in the spring of 2024 that the defendant submitted nearly 700 pages of documentation. And it was documentation that EGLE, in its brief, I want to point out, says didn't include documentary evidence such as site plans or photos. It included self-serving affidavits. Well, there were photos. There was a photo of Dr. Bagny's son, Stefan, standing on the historic structure that was from 1992. There were statements that it was there from the time Dr. Bagny acquired the property in '82 up until into the 1990s when it began to be eroded away. And then there were photos of, admittedly, a small amount of the original rock that was still in place. But the point is, it wasn't just self-serving affidavits. It was affidavits accompanied by photographs. And the affidavits noted that there was a government agency that used to maintain the wall for them, which is how, when I got the case, the consultant that we hired and I traced it to the Sheboygan County Conservation District and got the information that we got there. And so I think the issue here, as to this piece, as to the overall case, is that EGLE focuses, as Your Honor said, on this narrow slice of time in 2021. It overlooks the fact that all this evidence was provided in 2024. And yes, at that time in 2021, Dr. Bagny and Mr. Southwell, they're experts in their respective fields, but they're not experts in EGLE's permitting statutes. they were not aware that there was an exemption that probably applied. And we said that in our reply brief in support of summary disposition. It wasn't until they began responding to the violation notices that they said, wait a minute, you know, there's an exemption for a pre-existing structure. We probably apply there. And on that topic as well, that dialogue never happened during the permitting process for the reasons that we went over in the summary disposition briefing and argument, which was, and I want to point out something about EGLE's response brief here. I know the court's aware, I won't belabor it, but between Dr. Bagney, Mr. Southwell, and Mrs. Southwell, they repeatedly reached out to EGLE after the application had been submitted, when it was getting ignored for more than 4 months. They called on an average of roughly every other day for more than 2 months in the summer of 2021. They left messages saying this was an emergency. As Your Honor no doubt recalls, those calls went completely ignored. Mr. Oeming had the away message up that said he would not respond. And then in its brief, EGLE makes the statement here that I want to make sure I get the language right. EGLE was, this is from page 13 of their brief, and 13 of the original brief, I apologize. They filed a corrected version that changed the font to bring it within 20 pages. So 13 of the original 22-page brief.
Yeah, I had already made notations on the original brief, so that's what I'm thank you. That's what I'm.
Thank you, Your Honor. There's a section that says EGLE was also going to suggest other less impactful alternatives that could have addressed defendants' erosions concern without impacting the state's natural resources, but defendants got impatient and did the work without a permit, preventing any of this disclosure from taking place until after the stone had already been installed and paid for, at which points defendants were unwilling to make the modifications that EGLE believes are required by law. You know, Your Honor is familiar with the facts and history. I'm not going to get on a soapbox, but I'm just going to say I think that's a pretty egregious statement to make in this case, where the history shows that EGLE violated its own enabling statute by ignoring this application for months and months, and that the defendants made repeated outcry, said it was an emergency, made very clear that there was a threat to Dr. Bagney's residence. You know, it was not the defendants that prevented this dialogue from taking place. And so for EGLE's defense to essentially be, well, they didn't tell us all this stuff during the permitting process. But that's because EGLE ignored them to the point that it violated the law. And so
they did tell them that stuff before they filed suit, is your point as well.
A year and a half before they filed suit, yes, Your Honor, in the spring of 2024. And so this kind of gets to the overall lawsuit. There's another point about the argument, the Beverly Smith versus EGLE case that I want to make as well. But as to the overall lawsuit, I think the big problem EGLE has here is that it essentially had potentially exculpatory evidence a year and a half before it brought its case. Again, I'm using the term exculpatory a little loosely here, but you know, evidence that demonstrated that there should not have been liability here. And it should have investigated that before it brought suit. I think that's exactly in line with the holding of the Meisner Group case. We also cited the Adamo construction case and the Attorney General versus Harkins case that say, you know, there has to be a reasonable inquiry into the allegations. And I think when you've got fairly significant, potentially exonerating evidence, and you ignore that for 18 months, you bring the suit, and then at the summary disposition phase, you say, well, we need discovery to get that. You know, I just don't think that satisfies the standard. And so I think that there was a lack of evidence that supported the reasonable belief that EGLE's factual allegations were correct. And so I think we have a you know, devoid of arguable merit issue there. I'll also just quickly note, again, EGLE made the point about third-party discovery being available. Well, I mean, EGLE filed initial disclosures in this case, and they didn't mention any third-party witnesses, and they didn't mention anything that is typically gotten through third-party discovery. So I think this was more of a failure to adequately investigate. Additionally, we have an issue with EGLE's argument that it made in response to the motion for summary disposition, arguing that it did process the permit application and formally deny the permit. Now, as we've noted, and as Your Honor, included in the ruling on summary disposition, that is contrary to the plain language of Section 1301 of the Natural Resources and Environmental Protection Act. 1301 subsections 1307 subsections 4 and 6 provide that a denial is based on essentially the merits of the application. It has to include scientific analysis. It has to say what could be done to make the project permittable.
Well, on that question, I mean, you obviously, I agreed with your argument at the hearing. When we get into, seems to me your motion rests on two sort of foundations. One is the failure of the department to investigate its claim before bringing an enforcement action. Separately, you seem to also be arguing that the legal arguments that they made were legally frivolous. On that question, sort of a shorthand I use in my mind is like, for me to find a legal argument is frivolous. And this happens from time to time, thankfully not that often, I read one side and I read the other side, and I'm like, it's just so obvious that I struggle with how could an attorney with a straight face even make the countervailing argument. And it's just so apparent who wins on first blush, so to speak. When I have to spend a lot of time thinking through and it takes a lot of care and attention to figure out what I think is the correct ruling, it's kind of hard for me to think that was frivolous. Now, maybe that's an improper standard of just how subjectively obtuse I am in understanding the arguments. But why is my shorthand there either wrong or doesn't fit this case?
I think it doesn't fit this case because of EGLE's positions in the Beverly Smith case. We provided cites to a prior case where EGLE argued the exact opposite and prevailed in that litigation as to what it argued here. And not to belabor that, I know Your Honor's familiar with it, but that was a case, it was under the sand dune permitting statute, but it considered whether EGLE had denied or rejected a permit application under, as it applies.
And they were saying, well, we haven't denied it because we didn't take action.
They rejected that application, which they argued is not a denial because it's not a decision on the merits. And EGLE, the administrative law judge, and the circuit court all agreed. The Court of Appeals and the Michigan Supreme Court denied leave to appeal, indicating they either agreed or at least didn't feel it was appealable. And I think, we attached as an exhibit to our reply in support of summary disposition, the brief that EGLE and the Attorney General's office, same division Mr. Chanak is in, filed in the Court of Appeals with the argument heading 1, a denial means a denial on the merits. And the argument was that a refusal to accept or a rejection of an application is not a denial under Part 13. Now, to briefly address EGLE's counter argument in its briefing here, EGLE makes some arguments that are just frankly not correct at all. EGLE argues that the Beverly Smith case is distinguishable because that was a case brought under Part 353 of the Natural Resources and Environmental Protection Act, which is Michigan's sand dune statute. And the sand dune statute says you have a right to a contested case to challenge the issuance or denial of a permit. That's true. Whereas Part 301, the Inland Lakes and Streams statute that we're operating under, creates a right to a contested case to challenge, quote, any action or inaction of the department. But that's really a straw man argument because what was relevant in both cases, the question was not, the purpose Smith was cited for here was not to analyze whether the defendants
have standing or have the right to such a hearing. It was to say what constitutes a denial.
Exactly. And in both Smith and in this case, the question was, what is a denial under Section 1307? And, citing the exact same statutory provisions that we relied on, EGLE said the refusal to accept and process a permit application because the applicant didn't pay the fee is not a denial because it's not a denial on the merits. And that was, the administrative law judge and the court and EGLE cited to 1307 in making that decision. That's the exact issue that's before the court here. And then additionally, we had shown, EGLE knows full well, the rejection letter that it sent did not say your application is denied. It said your application is rejected because there was already this violation and we don't have to accept an after the fact permit. I provided in our reply in support of summary disposition an example of an actual denial letter, which breaks down the reasons for the denial. It says your application is denied. And it says at the end, you're entitled to an administrative contested case hearing. That did not happen here. And so I think the frivolousness of that argument, the fact that it's devoid of arguable legal merit, is not necessarily, if I was only arguing based on the statutory language, then I wouldn't think it was frivolous. The fact that we said, whoa, 5 years ago, EGLE said the complete opposite and prevailed all the way up on that. Every court agreed. Now, because it's necessary to survive summary disposition in this case, they're completely reversing position.
Well, it sounds like you're almost arguing that anytime judicial estoppel would apply, that by definition makes the second argument legally frivolous.
Not necessarily, Your Honor. I think what I'm arguing, and I can find the exact case, but we cited a case in our brief that says an argument is frivolous, meaning devoid of arguable legal merit, when it is contrary to clear, evident, and longstanding precedent. And so we've got clear statutory language, but I think the fact that the history of the Smith litigation, that was from, I believe, 2019 to 2020, I think that constitutes the clear, mistakable, and longstanding precedent. So, the estoppel,
except for the minor point that an unpublished opinion doesn't constitute precedent. So it's really here not that they were barred from making that argument by some legal precedent, but that they should be barred under judicial estoppel.
Yes, but I do think so. If I was to, let me think about that a moment. I mean, the circuit court opinion constitutes precedent in Oceana County. The administrative law judge opinion constitutes some kind of precedent in an administrative case. But I think the point is the real precedent is the statutory language, but it's not just the statutory language. It's the fact that EGLE has interpreted it a certain way in the past. The courts have agreed, and it's the same party, EGLE, and the same law office now arguing 180 degrees the complete opposite 5 years later. And so I think, and then in the brief, attempting to distinguish it in a way that is really a straw man argument that says, well, no, that's different. That was a sand dune permitting case. So it was about whether they had a right to a contested case in a sand dune permit dispute. Well, but that's not what we cited it for, right? Our argument is you took this position interpreting the statute one way. Now you're doing the complete opposite. And frankly, I think the statutory language is pretty clear. 1307(1) says EGLE has, within the processing period, it has to approve or deny the application. And then 1307(4) and 6 make clear what a denial is. And then we have the Smith litigation where EGLE took the position as to what a denial means. And so I agree with Your Honor, it's not the binding nature of the precedent on this court because we don't have any published appellate decision and we don't have a prior decision of the Sheboygan Circuit Court. I do think judicial estoppel was the correct basis for the granting of summary disposition on that point. But I do think that it rises to the level of frivolity when the statute's clear and EGLE has interpreted it and enforced it one way in the past, and then it does a complete reversal in this case. One other thing I would note on that point, as we're talking about the interpretation of 1307 and whether under 1307(9) EGLE was obligated to issue the permit or to process the permit in this case, right? Because that's our argument. EGLE's brief repeatedly argues, well, work had been done without a permit. EGLE doesn't have to issue an after the fact permit. And EGLE cites the unpublished Pagura case from the Court of Appeals that I cited for a different purpose in the summary disposition briefing. That was Department of Environmental Quality versus Pagura. And that's another, it misses the point. We cited Pagura in our summary disposition briefing as an example of a case where the Court of Appeals considered that estoppel could be invoked against EGLE It chose not to on the merits of that case, but we cited it to say, look, here's another example where this doctrine applies to EGLE, and we think the facts warrant it here. In its response to the motion for attorney fees, EGLE argues that Pagura demonstrates that they didn't have to process the permit application because in Pagura, work was done without a permit. EGLE could have issued an after-the-fact permit, but it had ordered restoration, and so it didn't. There are two huge problems with that, Your Honor. The first is that in Pagura, EGLE had not missed the permit processing deadline. So our argument was, in this case, EGLE violated its permit processing timeline. 1307 parentheses 9, contrary to what EGLE says, provides two forms of relief when that happens. One that EGLE acknowledges is that they have to refund 15% of the application fee. But two is that the department shall process the permit in the ordinary sequence in which it was received. Our argument here is that EGLE had missed its deadline and thus was required under 1307-9 to process the application before it decided, before any work was done and before EGLE decided we don't have to issue an after-the-fact permit. The statute gives EGLE the discretion of whether to process an after-the-fact permit or not, but it does not give EGLE any discretion as to whether to process the original application when it's missed its deadline. So you have two different statutory provisions. One is a may, the other is a shall, and the shall provision was triggered here first before any unpermitted work was done. And so that fact was not present in Pagura at all. Pagura just was your classic EGLE. There was no application where EGLE failed to process it in time. It was work done without a permit, and EGLE decided not to issue an after-the-fact permit, which it was within its discretion in that case. Not so here. And I mentioned there were two problems with EGLE relying on Pagura for that purpose. The second problem is that 1307-9 didn't have that requirement when Pagura was decided. Part 13 was originally enacted in 2004. It did not originally say that if EGLE misses its processing deadline, it shall process the application in the order in which it was received. Pagura was decided by the Court of Appeals in 2010. 1307 was then amended repeatedly between 2011 and the present, and the relevant language from 1307-9 was added in one of those amendments. So again, EGLE's reliance on Pagura for this point is just a complete miss. The facts that are relevant here were not present in Pagura, and the statutory language that the defendants rely on here did not exist at the time Pagura was decided.
Okay, thank you. One final question for you. You've asserted sort of, as I indicated, two separate reasons for me to find that the action was frivolous or not well taken and the attorney fee should be granted. I presume you think both are true, but that you'd only need to prevail on one of those arguments for attorney fees to trigger.
Your Honor, I would say both are true. I would say as to the factual piece with EGLE possessing exonerating evidence and not investigating sufficiently, that would trigger attorney fees for essentially the entire case. I would acknowledge that the legal argument about the definition of denial was not something that EGLE raised until the summary disposition phase. And so I think that would probably, I wouldn't argue that a frivolous argument would trigger attorney fees from before the argument was made.
Thank you. That's an important clarification. So one of them is that the entire action was frivolous.
Yes.
And the other is that an argument in response to a motion for summary disposition was frivolous.
Exactly.
Okay. Thank you.
And if I may, Your Honor, I just want to, I've been jumping around here. I want to make sure, just consult my notes real quick and make sure I didn't leave anything out.
Well, and I'll give you a rebuttal argument as well.
Thank you. I don't want to not raise something in my principal argument and then try to raise it on rebuttal. I'll be very quick. Your Honor, unless the court has any further questions, I think that's good. Thank you.
Good afternoon, Your Honor. Today we're here because defendants have brought this motion seeking fees against EGLE, kind of for two main reasons, as they've kind of stated, so I don't want to rehash that, but
maybe I can help narrow it for you that I'm just not persuaded today that I can find that the arguments made in your response or your responsive brief to the motion for summary disposition meets the standards of being legally frivolous. Unless, unless Mr. Bach says something on rebuttal that completely changed my mind, and then I'll let you argue it. But otherwise, I think what interests me more is the question about whether the department conducted a sufficient investigation before bringing the action, whether the action as a whole was frivolously brought.
Of course. Yeah, so that's my first argument, Your Honor. So obviously this standard, it's an objective standard. It's looking at whether or not there was substantial pre-suit investigation and whether or not EGLE made a reasonable inquiry. EGLE's process here follows what EGLE does for every enforcement proceeding. Granted, and as we conceded in the motion for summary disposition hearing, they didn't timely process the application, and there's some glaring issues with that. So I'm just going to set that aside for now. But in terms of EGLE inspected the site in October of 2021, they saw the structure. They made a determination that structure, even if the EGLE had done a site inspection on time and beforehand and considered everything, they determined that project was too substantial to have even been permitted. And then after that, EGLE sent out a violation notice with an order to restore in November. And this was kind of the prelude to 2 to 3 years of just negotiations and conversations with defendants between EGLE, where defendants were proposing, they brought forth this evidence with the maintenance exemption. EGLE considered that evidence, so that the idea that EGLE just neglected to consider any of that, I think is just inaccurate. EGLE took into consideration that evidence. That was reviewed not only by the EGLE staff that did the site inspection, but also an additional EGLE enforcement unit. It was then referred to our office at the AG's office, where before me, 2 other attorneys reviewed the file, and then because of workloads, it got passed to me. We drafted a complaint based on all that information, and that was reviewed by multiple attorneys. But the thing is when defendants presented EGLE with that evidence of the maintenance exemption, EGLE saw some contradictions with that evidence, because prior to 2024, and I know that there's a distinction in terms of, does it actually matter that they knew about the maintenance exemption then? No, we don't expect people to be literate on every little detail and nuance of the law. But here in defendant's original application, they indicated multiple times that this was a new project. And so they went into this project thinking it was a new project. They constructed the wall. We submitted exhibits 8 and 9 on page 10 of our brief. I think page 10 of the corrected brief, so I apologize, Your Honor. And I apologize for having to resubmit that as well. That was a mistake on my part with the font. But those 2 exhibits kind of show a side-by-side. The exhibit 8 on the left is the photo that defendants relied heavily on in the motion for summary disposition hearing, which suggests that there was some sort of pre-existing structure. And then if you look at the photo in exhibit 9 to the right of it, it shows a substantial structure. And so the rocks that defendants are, indicating were part of a pre-existing structure, and they conceded in their motion for summary mirror image of what they constructed. But that's kind of the problem with the maintenance exemption, is that the maintenance exemption requires an in-place and in-kind structure. And so to kind of circle back to my main point here, Your Honor, the contradictions that EGLE saw were, there's evidence that defendants didn't know about this pre-existing structure, because in their application, in 3 versions of their application, one submitted before they commenced work, one that was submitted while the work was ongoing, and then one submitted after the fact, they were asked if there was any previously regulated activity. So we know for a fact that defendants weren't aware of the pre-existing structure. So,
but that's not, that's really somewhat immaterial, as you mentioned, whether they knew about it or not, or whether they knew that they were entitled to that exemption or not. When they present you with evidence while this ongoing discussion is happening with EGLE, that then they come forward and say, hey, we've now uncovered some information where we think this fits under the maintenance exception, and they're relying on that. Then you've got to do more, right, than just look at the before and after pictures, which, you know, they're striking. There's a striking difference there, to be sure. But an investigation is more than looking at before and after and saying, well, gee, looks like they sure did a lot more. I mean, how do you know? I mean, if it's been there for years and years and years, there's a deterioration. At some point, you know, there's no indication that you forfeit the right to maintain it, but the extent of the maintenance certainly changes over time.
Yeah.
So you guys had more of an obligation to investigate than just comparing these before and after pictures, right?
Yeah, Your Honor. And EGLE did investigate. You know, they looked at their own records, and you know
Then why are they saying in the response to motion for summary disposition, this is premature because we need discovery to look at agency records?
I think that was more so, Your Honor, in reference to the conservation district, because that was a piece of evidence that wasn't brought to EGLE's attention until after the defendant's motion for summary disposition brief was filed, as they noted. So that was a new piece of evidence that EGLE had, because prior to that, the only evidence that defendants has presented establishing that their project fell under the maintenance exemption was the photographs in the.
And EGLE didn't make any effort to investigate historical aerial photographs of this area?
As far as I know, Your Honor, EGLE investigated and looked into their records and didn't find anything that showed, either proved or disproved, in terms of historical aerial photographs of this section. Because if you look at it from the top down, it's pretty difficult to tell if there was some sort of pre-existing structure there, especially prior to the project. As you can see, it was piled up with logs for years and years and years.
You saying that they did that investigation? It sounded to me like before you were saying that that summary disposition was premature because they need to conduct discovery from these third parties by, you know, getting these, you know, records and photographs.
I think that's one aspect of what EGLE was seeking with discovery, Your Honor. There's a couple other aspects as well. I think the most glaring thing is that these affidavits, you know, for the most part are technically self-serving affidavits because it's defendant Bagney and defendant Bagney's two sons that wrote them. And so I think EGLE wanted discovery, or EGLE believed it was entitled to discovery in that instance to depose those witnesses and kind of, you know, test that credibility to those affidavits, because that is kind of the central piece of evidence that defendants are relying on with regards to the existence of a pre-existing structure.
That's still, I mean, I just want to, I'm just looking at your response to the summary disposition. Yeah, no historical permitting records have been obtained. You said, okay, you said here's the discovery is necessary to resolve material factual disputes. And you said, at a minimum, the state is entitled to discovery directed at historical aerial photography, which seems to imply that they did not review the historical aerial photography before filing suit, right?
My understanding is that EGLE evaluated the evidence that they had, but they didn't have an opportunity to investigate, you know, what third parties might have possessed.
Well, they did have opportunity, they just didn't do it.
To my understanding, Your Honor, they didn't because they didn't have that third party subpoena power.
Well, a phone call isn't a subpoena.
And a
letter isn't a subpoena. Are you telling me that the position of EGLE is that the only way they gather information is by subpoena or court action? That they don't? I mean, you got investigators, right? They can go out and they can pick up the phone and call somebody or write a letter. You can write a letter, and or some of these historical aerial photography, these are publicly available stuff.
Yeah, and absolutely, Your Honor, I agree.
Historical surveys or engineering plans, prior owner records, those would all be a public record, right?
Most likely, Your Honor.
So you don't need a lawsuit to get that stuff.
No,
Without such discovery, EGLE's ability to rebut defendant's affirmative defense is diminished. So live by the sword, die by the sword. Well, couldn't that statement also be phrased as, without conducting that investigation, EGLE's ability to evaluate defendant's affirmative defense is diminished?
I disagree, Your Honor, respectfully.
Why? What's the difference between those two
Well, I think
statements?
there's other things that EGLE was seeking with, and I might not have worded it properly in my briefing, but there was other things that EGLE was seeking with discovery. So it's, you know, it's the historical photographs on the property. I think one of the glaring issues here is that the evidence that defendants put forth is evidence that defendants had an incentive to put forth because it supports their position. There's a very good chance that defendants are in possession of historical photographs that evidence that there is no historical or pre-existing structure at the site. But EGLE would have never received that until power of discovery was given, where EGLE could, you know, do record requests. And on top of that, we wanted to request contractor records between defendant Southwell and defendant Bagney because we think there might be some evidence in there.
Did you ask for those from the defendant or for before filing the suit? Did you say, hey, we want to evaluate this. Can you give me contractor records?
I do believe that EGLE, over the course of those multiple years, because defendant Bagney presented EGLE, as counsel had noted, with a 700-page document explaining everything. And EGLE took that into consideration. EGLE didn't just set that aside and decide we're going to file a suit anyways. EGLE took that into consideration and then spent 2 years evaluating that before it filed suit, or a year and a half before filing suit.
But can you point to anything where, because the third party information in the possession of third parties, it seems to me that, you know, you haven't pointed to any effort that EGLE made to secure that information aside from filing a lawsuit. Can you point to anything, any information that you say was in the possession of the defendants that during this discussion period, you asked them to provide and they said, no way, we're not giving that to you. So that the only way you could get it is through a lawsuit?
To be completely frank, Your Honor, I wasn't a part of those discussions. I'm a relatively new attorney, but.
Well, yeah, but I mean, you're here arguing. So I mean, that's
right,
not
Your
a
Honor.
particularly,
Yeah,
it's not a particularly helpful answer. I mean,
no, I know.
I argued a lot of stuff on appeal where I wasn't the trial lawyer, and your job is to know the record. So the answer to my question of, can you point to anything where EGLE asked these defendants for information in the possession of defendants, and defendants said, no, go pound sand, so that you had to sue them to get the information? Your answer to that question is no, I can't point to any single thing.
No, it's not, Your Honor. So my
What's your
answer to that question is that over the course of those communications, EGLE asked Dr. Bagney for evidence of this pre-existing structure, and Dr. Bagney provided, you know, all the evidence that she did, which is helpful for EGLE to kind of consider, you know, why or whether or not there was a pre-existing structure. But Dr. Bagney, at that point in time, when these negotiations are ongoing, doesn't have any incentive to provide photographs that are going to disprove her point, does she? So it's, for me, it's EGLE might have requested these things.
That doesn't quite answer my question. That's saying something different. You're saying we just didn't trust that they gave us everything. Is that what you're saying? We just didn't trust that we think they were maybe holding back.
Yes, Your Honor.
Okay, but my question was there ever a time when you asked the defendants for information that they possessed and they told you no?
Yes, Your Honor. That's
when?
So during those 2 years of communications where EGLE was communicating with, because EGLE investigated this thoroughly, it referred it to the Department of DNR, who came out and did a site evaluation on their own. The Department of Natural Resources made a determination that there was lesser impactful alternatives available to this site. So the EGLE, on many instances, I'm sure, requested all information from defendants.
I'm trying to ask you a very pointed and specific fact question, and you seem determined not to answer it.
I think
So I'll give you one more shot to answer my question, and then we're just moving on.
Okay, Your Honor. I don't have any paper records that EGLE requested that information, but that's mainly because those conversations were held over, you know, Teams or phone calls, or there's no records indicating what specifically EGLE asked for from defendants.
All right, so you have no records that the defendants refused any information, and you have no records that you tried to get this third-party information that you say you needed to file a lawsuit to get.
No, Your Honor, we do not.
All right. Why is that? Why doesn't that just resolve the question right there? Like you have to, I mean, when EGLE decides to file an action, listen, I get a paycheck from the government. Me being in court today, it's no big deal for me. You being in court today, no big deal for you. Government pays your paycheck. Government pays everybody's paycheck in EGLE. When a government agency decides to haul a citizen into court on enforcement action, that's a big deal for that citizen, right?
Absolutely. Your Honor.
Absolutely. They don't have an army of the Attorney General's office and its investigators, well paid by the state to do these things. And these are pretty specific, that they require specialists. I mean, I'm guessing that Mr. Bach here doesn't just hang out a shingle. I do drunk driving and divorce. He's here on a very specific issue with very specific experience. So this citizen is either at the mercy of the state, or they have to expend their own private resources to hire attorneys who are equipped to meet the full measure of the state in this area that requires expertise. All that's of course true. And I say that only as a precursor to say, doesn't the state therefore have a legal and frankly moral and civic obligation to do their due diligence before they subject a citizen to that process?
I would agree, Your Honor. And I think here what happened was EGLE took into account everything that defendant Bagney presented with regards to the evidence of a pre-existing structure. EGLE even changed its violation notice to account for that. Originally, this was a Part 301 and a Part 31 case. EGLE reduced that. They also established that defendant Bagney didn't have an obligation to remove stone structure above the ordinary high water mark. So they took into consideration this evidence that defendant Bagney presented to them, but that EGLE also made the determination with all that evidence in mind that there was no pre-existing structure, it wasn't permitted, and that what defendants did doesn't constitute maintenance. It goes well beyond that. Even if we assume that there was a pre-existing structure and it was properly permitted, the construction is in no way evidence to be in place and in kind. It could be much broader in scope.
All right, thank you. Anything else I need to know to understand your position?
Yeah, Your Honor, I would, if I may, discuss the Pagura and Smith cases, because I think
I'm ruling in your favor on that. I don't find that you're responsive. I don't find that your brief in the response to the motion for summary disposition on the denial issue was frivolous.
Okay.
You can tell me some things, but I've already decided I'm ruling in your favor. So you take a risk if you tell me things about that, you might change my mind.
Okay, Your Honor. I would like to just establish a record if that's okay.
You did in your brief. I don't need to hear argument that I already agree with you.
Okay.
That's a lesson you want to learn early.
Okay.
When a judge says they agree with you, you should not say more about it.
Yes, Your Honor. Do you mind if I just take a quick glance and make sure? I know we jumped around a little bit.
Go ahead.
I appreciate it.
And here's a free one for you, because I did appellate practice. When the Court of Appeals panel tells you, thank you, counsel, we understand your argument, sit down, because I've seen lawyers not do that.
I once had a judge ask me if I was trying to snatch defeat from the jaws of victory.
There you go. I've seen that.
Yeah, I think, Your Honor, I just want to briefly kind of highlight. I know that this court sided with defendants in the motion for summary disposition, but a losing case doesn't necessarily equate to a frivolous case. I think there were very considerable factual disputes, and that's, in part why we go to courts, is we try to resolve these factual disputes. And just because the court decided those factual disputes in favor of Bagney, I don't think necessarily means that EGLE's case was frivolous. I think I've highlighted most of the disputes that EGLE had, EGLE had with defendant Bagney's information and the evidence that they provided. I think that what happened was there's one set of evidence. EGLE viewed it in a very different light from what defendant Bagney viewed it. And that's why we brought it to this court, was to resolve that difference. In 2 years of negotiations and going back and forth and trying to figure out a resolution, proposing alternatives, that didn't pan out to be sufficient. And so EGLE here, based on this information, it had a reasonable belief or reasonable basis to believe that the facts underlying its complaint were in fact true.
All right, thank you.
Thank you, Your Honor.
I'd suggest that I'm persuaded there was not a sufficient investigation. So if you want to change my mind as to the summary disposition issue, you can, but you're good on the other one.
Okay, thank you, Your Honor. Just very, very briefly, to answer one of Your Honor's questions, there was never a time that EGLE asked Dr. Bagney, Mr. Southwell, or anyone affiliated with Northern Vista Lawn and Landscape for any document, and then they did not provide it. If anything,
any evidence in this record that they asked for information from a third party and the third party said no?
No. So most of the things I was going to address were things Your Honor just said I don't need to address, I believe. So I'm just going to review these very quickly. As to the legal argument, Beverly Smith was my best shot, and it sounds like Your Honor is not persuaded. So yeah, I think Your Honor, I guess the only couple of things I would say quickly, Mr. Chanik noted that EGLE, based on the evidence that was submitted, withdrew the allegation or the demand that they remove stone that was above the ordinary high water mark. Part
That
30
doesn't really have anything to do with the maintenance exception, right?
Correct. Part
The maintenance
301.
exception would allow them to maintain it, whether it's above or below, whatever it was.
You don't even need a maintenance exemption for what's above.
Oh,
It,
yeah,
301
I thought
only
that
applies
doesn't
below.
seem like it really adds up.
Thank you, Your Honor. Based on what Your Honor said a moment ago, nothing further.
All right, thank you. Well, this is this is a case where the plaintiff, Michigan Department of Environmental, Great Lakes and Energy, brought an enforcement action against these defendants, and the defendants moved for summary disposition, and the court has granted that. We're not here to, litigate that anew, of course, and I do believe that EGLE's filed an appeal from that, which is absolutely their right. We've got the defendants now here for a motion for attorney fees, which would, in this case, only be granted if the claim or the argument in response to summary disposition is frivolous. As to that second part, the assertion from defendants that plaintiff EGLE's argument in response to its motion for summary disposition was legally frivolous. I think it's clear from the last hearing, I didn't think a whole lot of the argument and I didn't agree with it, but I certainly can't say that it was frivolous. There were a lot of issues that had to be addressed. They were carefully addressed by both counsel. I don't think the legal arguments that were presented in the briefs or the motion hearing were frivolous, and I wouldn't award attorney fees based on that issue. The other issue, though, is the 109 and also the statute, that citation here, 600.2591, where an action is frivolous if the party had no reasonable basis to believe that the facts underlying the party's legal position were in fact true. The Meisner Law Group case cited by the defendants explains that the purpose of imposing sanctions for asserting a frivolous action is to deter parties and their attorneys from filing documents or asserting claims that have not been sufficiently investigated and researched, that are intended to serve an improper purpose. I don't think there's an improper purpose here, but really this comes down to, did EGLE sufficiently investigate and research the action before filing it? That hinges on the defendant's assertion that they were entitled to the benefit of this maintenance exception from the permitting process. And although there's a little complication on the front end because they'd asked for a permit, at some point while they're discussing things with EGLE, they assert the position that, hey, we didn't even need to submit a permit anyway, and here's why, this maintenance exception, and they give them some information to evaluate. And EGLE, took a look at that. They say today they adjusted what they were asserting based on that, but whether it's above or below the high water mark doesn't seem particularly connected to the maintenance exception. So I'm not sure what relevance that has to this question. And Mr. Chanik, described a lot of the time period involved, the number of discussions that were held between the department and its representatives and the defendant, the number of attorneys that reviewed it. Well, all those things are, I have no reason to doubt all of that. But that's not dispositive on the question of whether the department engaged in sufficient investigation before suing a citizen. And in response to, I think what's most telling is in response to the motion for summary disposition, the position of the department was, well, this summary disposition is premature because we need to conduct discovery. Of course, summary disposition before discovery is very rare. But they said, we need to conduct all this discovery. And the discovery that they described was stuff that you don't need to file a lawsuit to get. And I think that's the crux of the defendant's motion for attorney fees today, is to say, you can't just file a lawsuit to conduct an investigation. They're not fishing expeditions or investigative. Lawsuits are not an investigative process. They are an adjudicative process. You investigate and then you sue. And certainly there's discovery, during a lawsuit, but the fact that discovery is available after you sue does not relieve a party of the obligation to make sure that their suit is well-grounded in fact and in law. And here they say, well, we had to file a lawsuit to get historical aerial photography. No, they didn't. We had to file a lawsuit to get this information we had to look at agency records, or we had to get information from third parties. We needed to do that, so we had subpoena power. I mean, when I was in private practice, just on my own, and let me tell you, I did not have the special experience that Mr. Bach has. I hung out a shingle and took anything that would come in the door, and didn't have an investigator, didn't have a whole bunch of staff and attorneys, but I had a phone call. I had a phone and I had a pen, and I could write letters asking for information and make phone calls asking for information, and I did a lot of those things. And sometimes you get people responding to it, and if they say no, we can't give you that without a court order, well, now you got to reevaluate. Here, when I've repeatedly asked the department to explain, show me where you tried to conduct some investigation and the door was closed to you so that you needed to file a lawsuit to get at that information. And they've been simply unable to point to anything. And I think, although, I'm not suggesting that any property owner that prevails in an enforcement action gets attorney fees against the department. I know that's not the law. But I think the context bears repeating. I mean, I mentioned this during a question. I mean, the department has a vast amount of resources at its disposal. And when they file an enforcement action against a citizen, that's the full power of the state coming after that citizen. And the department doesn't have to worry a whole heck of a lot about its attorney fees because it's got a staff of attorneys and investigators. Whereas the citizen now is in the crosshairs and has to go out and, hire somebody who's able to meet that. So I'm not saying the homeowner gets attorney fees when they win, nothing of the sort. But what I am saying is that the department ought to do its due diligence before it puts a citizen through that ringer. And here, I think it's been demonstrated that they did not. There were gaps in their investigation that were significant and that were relevant. And by failing to do that, they've ended up losing the case. So for those reasons, I do find that there was insufficient investigation, that the action was not well taken, and that it was frivolous from the outset. So I would grant the motion for attorney fees and costs as a sanction. So the process for that is going to be as follows. As I understand it, there's a whole lot of work we have to do now. So Mr. Bach, I'm going to give you 21 days to submit a bill of costs and fees. And Mr. Chanik, I'm going to give you, will 14 days be sufficient, or you want 20? Okay, 14. I'll give you 14 days after that to file any objections to the bill of costs. If there's no objection to the bill of costs, the court will just simply enter it as a judgment. If you do file an objection and state the reasons for the objection, and then based upon what those reasons are, I'll see if I'll review whether I need to schedule it for oral argument or whether we need to schedule it for an evidentiary hearing, because we have to look at things like the reasonableness of the hourly fee, the reasonableness of the hours expended, all those Smith and Pergo factors and all of that. But in the meantime, Mr. Bach, you can submit an order that I'm granting your motion, but we have to follow this process to determine the amount of the attorney fees. Any question about that, Mr. Bach?
Only one, Your Honor, because
Yeah.
I've limited experience in the sort of post-judgment process on attorney fees. We had previously submitted and the court had taxed costs for our non-attorney fee costs that we just get as the prevailing party. So I'm assuming I should not include that in this second bill cost, right?
Any costs that have already been taxed, no, you wouldn't want to do that. Yeah. Would you agree with Mr. Chen?
Yeah, yes, Your Honor.
All right. Any questions from the plaintiff about that process?
No, Your Honor.
Okay. Thank you both very much. You have a good day.
Thank you, Your Honor.